The case filed by Attorney General Githu Muigai challenging the constitutionality of the People's Parliament currently established by 15 county assemblies is now in the hands of Chief Justice David Maraga. This is after Justice John Mativo forwarded the case to the Chief Justice to constitute a bench of judges to hear and determine the case.
If I look at it and I find this matter fits that description, I appreciate your approach. So why you deny me the chance to exercise that discretion?
Justice Mativo ruled that although a judge of the High Court can hear any constitutional issues, the case by the Attorney General raises weighty constitutional issues. Attorney General Githu Muigai had filed an application seeking the matter to be heard by a three-judge bench. In the case, the Attorney General argues that the formation of People's Assembly is not in line with the constitutional framework and the spending of public resources on unlawful activities through its establishment is in violation of the Constitution. Meanwhile, the High Court has dismissed a petition challenging the election of Ndiritu Muriithi as Laikipia governor. Lady Justice Mary Kasango ruled that claims that some voters were denied to vote during the August general election were unfounded, and the evidence produced by the petitioner did not prove allegations that the exercise was marred by electoral malpractices. In the case, the petitioner claimed that some voters did not participate in the electoral process as they were involved in a security exercise that was being conducted in the area. But in the ruling, the court found that the claims were not based on evidence.
This court finds that the Pokot community were not affected by any alleged security operation. And in making that finding, I add that had there been such interference with the right to vote of the Pokot community, such a matter was an election offence under Section 10 of the Election Offences Act. No evidence was there that any complaint was ever filed in regard to that alleged interference.
The court further ordered the petitioner Sam Ndungu to pay 12 million shillings as costs for their case.
We have been treated to nearly 5 months of the rights of Laikipians and our rights as leaders being trampled upon with no evidence. And as the court has rightly found out, all that the petitioners had done is to allege a whole variety of allegations that obviously have no basis.
Laikipian people are happy, and we want to tell them that expect more from what you've seen. If we did that under the duress of the court, what about now when we are free to work for the people of Laikipia? We shall deliver on our promise under the leadership of Ndiritu Muriithi as the governor of Laikipia, and we are fully behind him.
And Kerugoya High Court has allowed former Kirinyaga Senator Daniel Karaba to withdraw his petition challenging the election of Kirinyaga Senator Charles Kibiru. Justice Abigail Mushira, however, ordered Karaba to pay 10 million shillings as costs, arguing the petitioner withdrew the case on the day when the court was preparing to hear the final submission from all parties. In Busia, the High Court has upheld the election of Teso South Member of Parliament Godfrey Omuse. The decision by Judge Kiaria Waweru has dealt a blow to the petitioner, former Teso South Member of Parliament Mary Emase, who was also slapped with cost of the case amounting to 2 million shillings. Mary Emase had filed a case citing erroneous counting and tabulation of results. She claimed her votes were treated as rejected and that her agents were harassed. The judge said the election was conducted in accordance with the law.
Nothing has been proved to the contrary. The first respondent was validly declared as the elected member of Parliament for the St. Teso South constituency. The petition is accordingly dismissed.
Ilikuwa tu kuconfirm kwamba tulishinda kura. Hatukuiba kura. Sindio? Tunawafanyia kazi kama mbunge. Wale ambao tulikuwa nao tunabishana, tafadhali tufanye kazi pamoja.
And finally, the High Court will on Monday next week decide whether city lawyer Nelson Harvey's name will be in the ballot during the Law Society of Kenya elections scheduled for February this year. Harvey moved to court to challenge the move by LSK to disqualify him from contesting for the president's position on grounds that Harvey is ineligible and he has not been a member of the LSK Council as required in its statutes. Harvey, however, argues that the society's rejection of his nomination papers is unlawful and lacks basis. Ben Chumba, reporting for Scales of Justice.